All right. Hello, everyone. We are going to get started. So today we are going to be talking about confidentiality and sexual assault response teams. I do want to mention that this presentation is supported by the Office of Violence Against Women, and we do have a disclaimer listed at the bottom of this first slide. I did notice someone in the chat stated that they are muted, and all of our attendees today are going to be muted throughout the entire presentation. Carol and I will be on camera, but you can use the chat to interact with each other as well as ask questions and the Q&A function. And we can get into that more in just a little bit. So without further ado, my name is Miranda Gonzalez, and I am part of the Sexual Violence Justice Institute at the Minnesota Coalition Against Sexual Assault. I am one of the rural project coordinators here at SVJI, as we abbreviate our organization to, and I use she, her pronouns. And I'll have Carol introduce herself as well.
Hi, everyone. I'm very excited to be here with you today. Thanks, Miranda. I am a senior staff attorney on the Victim Rights Law Center's Technical Assistance and Training team. I focus on confidentiality law in that role. And I also manage our direct representation team, which gives me an opportunity to see how the sort of more theoretical TA side of things lines up with the actual practice that our attorneys have when they're representing survivor clients. The most important thing on this slide is my email address, which we will show both our email addresses again at the end, and we encourage you to reach out to us with any questions.
Thanks, Carol. All right, so today we are going to spend time understanding and refreshing our memory about sexual assault response teams. We're also going to identify team members' different legal confidentiality requirements, explain how confidentiality requirements may impact a team's work, and also discuss how to navigate these different confidentiality and disclosure requirements. A couple of housekeeping things that we do want are going to ask everyone to keep in mind is that this is a national webinar, and so we are not going to be going into jurisdiction specifics as it comes to confidentiality. With that, if you have questions that are jurisdiction specific, you can feel free to send Carol or myself an email after this webinar where we can give you more information. In addition, we invite you to ask questions throughout this presentation using both the chat and Q&A features. We will answer them both in real time, or depending on how timing is going, we might save some for the end, but feel free to put all of those questions in the chat and Q&A as we are talking, and we will answer them as quickly as we can. However, we do ask that you do not ask any specific questions that are case related, as this is a public webinar and this presentation is being recorded today. So just kind of general confidentiality questions, not anything case specific, please. With that, we are first going to begin talking about your role on a SART and kind of get to know everyone a little bit more. So we are going to start off with a poll asking, what's your role on a SART? A culturally specific program, advocate or related staff, victim service provider, law enforcement or corrections, another role, a community member, healthcare provider, including claims, prosecutor or related victim assistance provider, or are you not a SART member and just looking to learn a little bit more? We'll give folks a couple of moments to answer that question as our results come in. All right, I think we can end the poll. And then share our results. So we have lots of victim service and victim service providers and advocates here today. One law enforcement individual, welcome. We have a few healthcare providers and a few folks from culturally specific advocacy programs or related staff. So welcome everyone. Thank you so much for introducing yourselves. All right, so we are going to spend just a little bit of time grounding ourselves in what a sexual assault response team is. So the first thing that we would like to point out is who is working with survivors of sexual violence. So this graphic kind of shows all of the different disciplines that impact and can be working with sexual assault survivors. So that can include victim advocates, law enforcement, prosecution, corrections, forensic medical health providers, culturally specific programs, depending on the community, college and universities, and also faith communities, are just some examples of folks and professionals that work with sexual assault providers. SART teams or a sexual assault response team. And Carol, you can go to the next slide when you have a moment. Thank you. What is a SART? A sexual assault response team is essentially a group of all of those representatives that we talked about on the previous slide, folks that are working with victim survivors coming together on a multidisciplinary team. So it's folks from all different disciplines coming to work together to look at the response to sexual violence within their community. And it's focused on collaboration and systems change. And we'll talk a little bit more about that later in the next slide, but it's really devoted to changing that response within the community. The SART teams that we talk about today also use a continuous improvement process within a cycle that we will show a little bit later. It's essentially one of many strategies that folks in the community can use to improve the outcomes for victim survivors within their communities. So like direct service can also be a form of improving outcomes for victim survivors. This is looking at collaboration and seeing how folks are talking together and interacting with each other to improve outcomes. There are a couple of different types of SARTs that we are going to be at least briefly touching on today. The first is an acute response. So an acute response typically focuses on a single case so for example, this could be where a detective, a single advocate, and a prosecutor all come together and meet about one specific individual case. The focus is on changing the individual response to that victim survivor. And it needs individual participation. So the detective that is directly interacting and directly doing the investigation is the individual that is on that acute SART team. Process depends on each responder because they are the ones that are directly providing the service for this particular case. And the results are targeted and small scale, right? They're really, really focused on the response with that single individual. On the other hand, systems change SARTs are focused on the entire case and processes within the community. So they're not just focused on one individual, they're focused on all victim survivors throughout their entire community. The changes that are being made are based off of agencies and systems processes. A lot of times we can see these changes through protocol writing, where different agencies and different disciplines write down and agree to how they will interact and collaborate with each other. For systems change start, agency-wide participation is needed. So essentially, right, you got to get everyone on board because everyone is responding within that specific community. It embeds processes that stay consistent throughout the entire response and are not dependent on like one detective or one advocate. They are the same for each individual service provider. And the results of systems change starts are long-term and widespread change. I do want to call out that we today are going to be focused on systems change starts. So when we're talking about confidentiality, we're not talking about when team members get together and there's like one representative from each discipline focused on one specific case. We're thinking about confidentiality as it relates to these systems change, these kind of bigger picture starts in teams and forms of collaboration. We're going to spend a little bit of time talking about what systems change actually is. So systems change is essentially just improving the system's response and increasing that collaboration, that connection between various disciplines. It can include enhancing strengths between disciplines and enhancing relationships that are already strong, addressing shortcomings and gaps within the response, and ensuring support and engagement between various disciplines and various community members and responders, as well as having this continuously improving process. You keep coming back to and looking at, okay, where are the gaps now? We may have addressed some shortcomings, but there might be different ones that now we need to look at. So it's really a continuous cycle. With that, we do here at SVJI think about this as phases of systems change. And we divide this into kind of 3 different steps. First, assessing the status quo, and that's figuring out what you have, what your community response to survivors looks like, making the change. So that's the action step. That can be writing protocols or having trainings depending on your team, and then measuring the change, which is doing some sort of an evaluation to see where are you now that you've made those changes and have taken that action, and what does that look like for your community. And again, as you can see with the wheel, this is a cyclical process. All right, so we're going to spend a little bit of time talking about who is part of a SART. I like to think about this as kind of 2 different buckets of folks. So first we have governmental partners. So this can include law enforcement, prosecutors, corrections, adult protection, child protection. Sometimes depending on your team, you might also include like victim witness professionals as part of like those governmental partners. So those are some of the folks on the team. We also have community partners, folks that are not whose discipline is not based in the government. So this can be advocacy, medical providers, colleges and universities, kind of dependent on your community, faith communities, culturally specific groups, essentially like any major points of disclosure of sexual violence, those community partners can be invited to the SART team. All right, so with who is on the SART team, I just wanted to take a little bit of time to talk about the team of professionals and kind of get us in a specific frame of mindset when talking about confidentiality. So it's important to think about that each individual member within is trained in their specific discipline and they have experience in their specific discipline, right? So when an advocate comes to the table, their lens and their training and their experience is going to be very specific to advocacy. And they'll have some ideas as far as what success looks like from an advocacy point of view, compared to like prosecution might also be on the team, and they have very different training and experience compared to advocacy. And what and how they define success within the response might look different than an advocacy organization. It's important to keep in mind that each individual member on the team also has different legal and professional requirements for their work, right? So advocates have confidentiality requirements that are very, very different than law enforcement or prosecutors or sexual assault nurse examiners, and Carol will get into some of these details a little bit more later on. But one of the amazing things about the SART is that you're bringing all of these different perspectives together to really look at the response in a holistic view. But we also have to remember that each individual team member comes with their own authority and responsibility to their part of the response, and that there will be differences between team members. A lot of times where we see that come up, right, can often be confidentiality requirements. But it's important to keep in mind too, that everyone has their own role to play. Every role is equally important and equally necessary in order to be on the team. So I like to think of it as like the Justice League. So like Superman, it has like one very specific role compared to like Aquaman on the Justice League, right? They all have their different skill sets, and together they're really able to kind of look at all of the different ways to save the world in superhero talk. So similar to that SART team, right? Everyone is going to have different skill sets, and everyone is needed in order to uphold and improve the response to sexual violence within their community. All right, I am just going to take a couple of moments to pause to see where folks have questions. All right, someone asked, will we get a copy of the presentation? Yes, so this presentation is being recorded. So we will send a link out as far as the actual recording goes. And then as far as the slides go, I might have Carol answer that. She might know a little bit more than I do about the slides. But yes, we are recording this, and we will send out the link when it is available.
I am unmuted, but I'm having trouble getting my video back on. And so I will say, without my video, that I'm glad to make, we can definitely make the PowerPoint available. Glad to distribute that. I'll leave that to SVJI, how you want to do that, but I'm glad to get it to you. Oh.
Thanks, Carol. Do we have any other questions before we continue? All right, someone wrote in the chat, when you have an existing SART, when you have an existing SART, is it protocol or a good idea to routinely go over confidentiality and what it may or may not mean to members? That's a great question. And I think actually, I don't know, Carol, if you're having, I know we talk about this a little bit.
Yeah, I'm glad we will talk about it a little more, but it's a great idea. I love this idea. I think it's really important, especially as you have turnover on the SART, that you just want to make sure that everyone understands why some people are able to share information a certain way and others aren't. So love the question too, and give it an enthusiastic yes. I'm so sorry that I don't know. I mean, clearly I was able to turn off my video, but I'm just not finding a way to turn it back on, which I'm fine with, but I just want to explain. Oh, can you hear me at this point?
Yep, we can hear you.
Okay, because now I don't even have the frame that allows me to mute or unmute. So we will find our way forward, but just know I'm flying blind a bit. I can still see the chat box and the questions and answers, and I will continue with the PowerPoint. Miranda, are you ready for me to pick things up?
Yes.
Excellent, thank you. I want to thank all of you who are attending today for the time you took to give some thoughtful responses to our pre-webinar questions. I feel like when I'm preparing for a webinar, the conversation starts when you write those questions or tell us about your work and what you're doing with the SART. So thank you for that. You are, to the extent to which those of you who registered are actually here, you have such a wide range of experience. From some of you provide expert support to other SART teams, to some of you aren't on a SART team but are just wanting to learn more about them. And it was nice to see the roles of you who are here today and to see that diversity too. And you're from all over the country. So I wish that we could have more conversations with each other, more than are allowed during a brief webinar, but just know you're all fabulous and have interesting perspectives and great questions. And thank you for being with us here today. Speaking of such conversations, we would like you to please use the chat to share why you think a SART should care about survivor confidentiality anyway. Why are we talking about this? Why is it important? And while you're writing responses to that, I just wanted to highlight two things that came up in that registration. One was someone asked, will my abuser be able to contact you or learn where I'm staying in shelter? Which I think is a great point about safety. And why confidentiality, how it's linked to safety. And then someone else commented about additional ways to gain trust of survivors without oversharing or breaking confidentiality. Yes, as one of you just wrote, that trust piece is so important. Anything else? I'm just trying to get to the top because you're going fast for me, which I love. I love that you're engaged faster than my screen allows me to keep up with. So talking about this idea of going deep into the weeds and skirt with blowing confidentiality, there are a lot of issues there. I'm not sure exactly what happened with that, but I think that can happen, that you forget about confidentiality, and that it can mean different things to different represented communities on the team, definitely, which is why I love this idea of routinely going over confidentiality and how it works with your SART. Control for the survivor, yes, definitely consent, control. As people who are working as part of a violence abolition movement, consent is key. Trust, safety planning, yes. Safety, yes. Build trust, definitely. You may have ethical and professional obligations. Trust, I love that trust is coming up so much. I feel like that is one of the key things. And then this professional responsibility. So there's this, I'm seeing this juxtaposition between a survivor-centered understanding of the importance of consent and autonomy and control of information and safety for survivors. And there's also this piece about people's different team members, different professional and ethical obligations. They may have obligations about information sharing related to funding that they receive, requirements that the funders have. There can be a legal liability question between whether someone shares information that they weren't legally allowed to share, or not sharing information when they're required to share, such as in a mandatory reporting situation. And then I see the two of these coming together, the survivor trust and the professional responsibility, all coming together in the SART teams and the individual members' organizations' reputation in the community. Are you going to be known as someone, as a safe space where people can share information, or are you going to have a reputation for not protecting information that's shared? Thank you very much for all you contributed to that conversation. So we're going to continue engaging through a scenario. And in this scenario, I wanted to just cover introduce people a bit and say that Anna uses they, them pronouns. It can just want to be clear about how we're using the language. The team that's referenced is a SART, or it could be a CCRT. LEA and LEO are shorthand for law enforcement agency and law enforcement officer. And the victim advocate referenced is a Violence Against Women Act funded sexual assault advocate. I want to highlight that you're being asked to give feedback on a scenario before we discuss the key points related to that scenario. So oh gee, okay, one moment, please. I'm resharing my screen. And I want to flag at this moment too that I have the message that's not, I now have the box back with my name, but when I try to share my video, I'm getting the message I got earlier about not being able to do that. And host disabled participant screen sharing is a message I'm receiving when I'm trying to share my screen again. So I'm going to finish up a couple points with the hope that my screen sharing capacity will be restored before, so that we can move forward. But I just want to highlight that these are pre-learning questions, so there's not an expectation that you know everything you would need to know to give the best answer. So just make your best guess as to what the best answer is. And then throughout the scenario and the rest of our time together during the webinar, ask questions, engage in conversation. Feel free to say how you see it differently. I am now empowered to share my screen. One moment. Is it back? Do you see it? Woohoo! All right. So let's turn to the scenario. A law enforcement agency has brought Anna's closed case to your team for review today. The law enforcement officer shares a signed written release from Anna that allows, quote, all team members to freely discuss all information, end of quote, about their case. During the team conversation, the officer asks a local victim advocate if Anna ever came to them for services, and if so, what did Anna tell them about their sexual assault? May the advocate share this information. So the poll is, you can answer yes, maybe, or no. Yes, the law enforcement officer brought a written release signed by Anna, allowing the team to discuss all information about Anna's case. Maybe, does the advocate have a separate release from Anna allowing the advocate to share information? Or no, freely discuss all information is not specific enough to be an informed release of information. What do you think? Please vote for one. I will say from a tech perspective, I am not seeing the usual results showing up with the poll response.
Okay, guess I'm not sure what's going on with the tech side of things, but I know we're at about 70%. So we'll give folks a couple more moments. Right now, we have maybe and no are kind of tied.
Okay. Thank you. Feel free to close it when you're think it's a good time, and let me know what things say.
Yeah. All right, so I think we can end the poll and share the results.
Oh, I see that.
Okay.
Just to let you know, I see the results. Woohoo. Okay, so we have mixed responses, which I'm really glad about. So I see that most of you are with maybe or no, and I will say to, jump ahead a bit, that I think maybe is the best answer, but I think C is also a good answer. I do not like the yes answer for reasons that we will cover in our time ahead. The release needs to be for the VAWA-funded people on the team, for reasons we're about to explore, needs to be something that the VAWA-funded person does with the person whose information is being released. So let's talk some more about that and explore that more deeply. So confidentiality, what do you mean when we're talking about confidentiality? To me, confidentiality means a professional's obligation not to share the information of someone who has come for help within their professional capacity. So it's an obligation that the professional has. Lately, I've been thinking about how the better way to frame this might be that we're talking about in what circumstances may or may not someone share information. This is all about information sharing. And I want to go back to an earlier slide about these different roles on a SART. And I think that, as was mentioned earlier by Miranda, it's important to remember that different partners have different obligations with regard to how they share information. And it's important that you don't need to just know your information sharing responsibilities, but you need to know the information sharing responsibilities of everyone on the team so that you work more smoothly together and there aren't expectations that certain people are better participants because they're sharing more information, and the people who aren't able to share information because of their professional obligations, among other reasons, are not team players, for example. So let's look at what these sources of confidentiality law are. Tribal law comes into play in many jurisdictions, and it needs to be something that you think about to the extent it applies to where your SART is doing its work. Just there are resources available, and certainly the conversations you have with people who are in your jurisdiction who understand tribal law are a resource, especially because tribal law is not always written down. Sometimes it's passed through oral tradition, so it can be more complicated that way as far as just getting access to what the law is. Federal law, we're going to spend a fair amount of time discussing. And then lastly, there's particular law where you do your work in your state, territory, or the District of Columbia. And as Miranda mentioned earlier, we're not going to be able to talk about those specific laws for you today, but there are resources available. And with that, I want to ask Heather to please share a link to the VRLC's resource request form. This is something you might want to have access to throughout the rest of our webinar, because I'm going to be mentioning resources that you might want to have, and the best way to request those if we're not otherwise providing them is by filling out this form and sending it to me, ideally, and then we'll send those out to you. So we have jurisdiction-specific resources that cover privacy generally, that focus on minors' privacy, and one that focuses on clergy privacy, mandatory reporting, and clergy penitent privilege, because that can come up in campus work with chaplains and campus ministers who may be, given the ways in which Title IX changes, the only people on a campus who can have privileged conversations with survivors. So if those would be helpful, feel free to request them. In addition to these laws, excuse me, there are also professional and ethics rules that can affect confidentiality. Let's look at federal confidentiality laws. I want to start with the Violence Against Women Act, the Victims of Crime Act, and the Family Violence Prevention and Services Act. These acts provide the foundation for federal funding that supports many victim service providers across the country. There are confidentiality laws that we're going to go into depth with that affect that practice. Any of you who would be interested in seeing how the VAWA, VOCA, and FIPSA confidentiality provisions line up against each other, they're very similar, but there are some places where they are different from each other. We have a comparison chart that, Heather, I think you have a link to that we can put up now so that you could look into that if that's something that would interest you. You can also use our resource request form to get that. Thank you, Heather. Similarly, in the healthcare context or school context, the Health Insurance Portability and Protection Act, HIPAA, the Family Educational Rights and Privacy Act, Title 10 come into play. The FERPA, how FERPA comes into play is that there can be this complex analysis around whether or not a school record, if their school has a health clinic, for example, how those, if those records are medical records or school records. And we have a comparison chart that lines up those different acts with VAWA and how they relate, so that if you have people with different responsibilities or just want to understand this better for your own reasons, we have that chart. I think I sent that to you, Heather. I hope I did. If not, you can request it on the resource request form. And lastly, the next example is Title IX and the Clery Act, which can have an impact on information sharing within a school context. And lastly, the Prison Rape Elimination Act and similar provisions can apply to work that you might be doing in custodial settings, prisons, jails, juvenile detention, immigration detention, those sorts of places. So before we move on, I want to reference the Title IX and the Clery Act. If you're providing services or a SART that interacts with campuses, we have a campus workbook that you can request with the resource request form. Similarly, we have resources for protecting privacy in custodial settings that you should feel free to request if they would help you with your work. Lastly, I want to touch on Brady v. Maryland. Brady v. Maryland is a federal criminal case that established that the prosecution in a criminal case must turn over all evidence that might exonerate the defendant to the defendant upon the defendant's request. What are the implications of this? The implications for the purposes of today's webinar is that victim assistants working in a DA's or law enforcement office, for example, that information shared should be assumed to be disclosable to the defendant. A separate point that isn't from Brady, but I just want to flag at this moment, is that public records law, especially with closed cases, is something that people should keep in mind. But it would depend on how the public records requests or FOIA or sunshine laws work in your jurisdiction, but that's something else to think about. So, back to the very helpful information that you provided when you registered. There was a question that someone asked: can judge or parents make members of a SART share information? And others of you asked questions about how does this all work with minors. Someone else commented that as advocates, we don't share the name of the survivor. Law enforcement officers and prosecutors not bound by the same confidentiality law, and sometimes they do share names. And the last question: what can law enforcement be told? And so much of this, again, depends on someone's role and whether or not they're receiving, for example, VAWA funding. So let's look at VAWA confidentiality. people who receive VAWA, VOCA, or FIPSA funding shall not, this is in federal statute and federal regulations, this legal requirement that they shall not disclose personally identifying or individual information collected in connection with services, those are victim services, requested, used, or denied. And I just want to flag here that it's even if someone comes for services and they don't receive services because the program is at capacity or someone doesn't meet their case selection criteria, for example, that information is protected by this law. There are three cases in which situations in which that information can be shared, that personally identifying information, and that is if the person whose information it is has given written and informed consent, there's a statutory mandate to share the information, or a court mandate to share that information. Before we look at all three of these keys, what are we talking about when we're talking about personally identifying information? First of all, I like to think of it as anything that might be on a driver's license or similar ID. Things like someone's photos, certainly their name, their address, their birth date. Sometimes characteristics, if they're unusual, like someone's gender identity or eyes or height. These are all things that can be personally identifying. Similarly, things like IP addresses can be personally identifying, the sort of footprints our tech leaves behind. And then lastly, things like someone's faith tradition can be personally identifying if they're from a religious minority in the community, or if they have a faith tradition or position that's not common within a community. The language of VAWA says, in describing personally identifying information, that it's information likely to disclose the location of a victim and any other information, including date of birth, racial or ethnic background, or religious affiliation that would serve to identify any individual. So that's the sort of information that VAWA, VOCA, and FIPSA are protecting. So the first way that information can be shared is with a release of information from the person whose information it is. There's a required process in the federal law that we're going to touch on briefly, and that is that someone receiving this money, the Victim Services Program, needs to discuss with the person whose information would be released why the information might be shared, who would have access to the information, and what specific information might be shared. Then those two parties need to agree about what information will be shared and with whom. You don't need to agree about why. And lastly, that agreement needs to be recorded in writing and signed by the person whose information is being released. The release requirements are further that the person whose information is being released needs to give informed consent. Implications are understood. So what that means is, one example is that if the person whose information is being released speaks a different language than the person who's releasing the information, need to make sure you're on the same page. I want to flag a resource that we have at this point that is an interlineated Spanish and English release form, so that an English speaker and a Spanish speaker working together can make sure that they're agreeing to the same thing. We also have a plain language release of information that can be helpful with informed consent. So feel free to use that resource request form if you would like to see those. The release has to have a specific scope and limited circumstances. So that's why the release that Anna had that was brought to the SART in our scenario was not VAWA compliant because it wasn't specific. It was freely discuss all information was the frame. So it wasn't specific enough to meet these requirements. Now, if there's no one on the team who has to follow the VAWA requirements, it may be a different situation. But remember, in our scenario, the victim advocate received this funding. There can be no blanket release, so that can't have a situation where we'll just sign it and we'll figure out what's going to be released later. That's not allowed. It needs to be for a specific and reasonable duration. It has to be revocable. That revocation of the release can be oral or in writing. It doesn't have to be in writing. It can't be a condition of services, and as we've mentioned earlier, it needs to be written and signed. There's not a requirement that that writing be on a piece of paper or that it follow a certain form. And the signature doesn't have to be with pen and paper. It could be a digital signature, but you want to make sure that that signature is one that will protect the survivor and not be a situation where someone might be an imposter pretending to be the survivor releasing the information. If information is released without this going through this process, it may be a federal data breach that would require follow-up. Briefly, who signs the release? If the victim has legal capacity to consent to service, only the victim is required to sign the release. This is what's going to happen in most cases. And if a minor lacks the legal capacity to consent, then that minor and the non-abusive parent or guardian signs. And the legal consent means if they're permitted by law to receive service without a parent or guardian's consent, then they can sign the release. If the minor can't, then only the non-abusive parent or guardian must sign and inform the minor as appropriate. This would typically come up with a child who's too young or doesn't have the mental capacity to understand what's going on. And then if an adult with a guardian, if that adult lacks legal capacity to consent, only a non-abusive guardian must sign. All right, that was a lot. Feel free to ask any questions you might have about this. So given all that, let's just briefly look back at Anna's case, where the law enforcement officer brought a signed release that allowed all team members to freely discuss all information, and then asked the victim advocate if Anna ever came to them for services, and if so, what did Anna tell them? And we can see now that yes doesn't work because the advocate didn't have the conversation with Anna about what information would be shared and what those implications are. If the advocate had a separate release from, if Anna had a separate release from the advocate, or the advocate were permitted by Anna to share the information, then they could share the specific information that Anna allowed them to share, not additional information. And lastly, freely discuss all information is not specific enough to meet the requirements for a VAWA, VOCA, or FIPSA release, but specifically, clearly VAWA, and I would think the other two. All right, that was all the release of information that any VAWA, VOCA, or FIPSA members of a SART team would be expected to need to share information, unless there's a statutory mandate to share information. I would not expect this to be the case. Typically, a statutory mandate would be mandatory reporting laws in your jurisdiction that might require an advocate to release certain information, or it could be for mental health care providers, could be a duty to protect or warn that's found in statute where you work. Court mandate is a court order or case law that requires the release of information in your jurisdiction. So those are the only 3 times that victim service providers may release information if they are receiving VAWA, VOCA, or FIPSA funding. This is best practice for many other organizations who are not receiving that funding, who are providing victim services as well. But keep in mind the Brady exception or the Brady requirements that would indicate why this probably is not the case for other members of the SART. And it's good to know who has what responsibilities. I'm going to pause for a moment to see if you have any questions, comments about any of this. Oh, I see a question. I'm just gonna make sure it's the top one. Yes. Are VAWA, VOCA, FIPSA funded victim service providers able to speak about a case without identifying information, or a case detail seen as identifying information itself? Love this question. It's a great question. If it's not personally identifying information, or if people are speaking about a case among other cases, saying something like, in the past 6 months, we've had several cases where X, Y, or Z happened, or any other way where they're describing what's happening in a way that people do not know who they're talking about, that is allowed. But if, for example, the team meets and says, that case that was in the news 3 weeks ago, and everyone knows who the case that was in the news 3 weeks ago is about, that's personally identifying. So it hinges on whether or not in the conversation, anyone else in the room knows who you're sharing information about, unless you have permission to share it. I hope that makes sense. Any other questions, comments, thoughts before we move to our next scenario? You can always ask later, but I'm going to move on, but I will come back and look. Okay, next scenario. During your team's SART meeting, let's say, I think that would be a better frame. One member of your team is frustrated that another member of the team is not sharing much concrete information about how their organization was involved with a string of high-profile sexual assaults in the community. How might your team approach this disagreement about how to move forward? And your options are, for your poll, ask the person who requests the information how that information would support the team's work. Ask the person who is not sharing the information why they aren't sharing it. Any member of the team could remind the team how the information supports the team's purpose and/or any limits team members have with sharing information. All of the above. What's the best answer, do you think? I want to report from a technical perspective that I can see the poll responses this time. So thank you. Just give a few more seconds for those of you who haven't yet had a chance to respond to let us know what you think. Okay, I'm going to end the poll and share the results. So the second option was not well received. I'll just note that. And then the other three all had some significant engagement with thinking that there are a good question or way to approach a different understanding about what to do. Though I will acknowledge that those of you who said all of the above were also accepting the second option. So let's hold that information. I think that any of these answers are helpful prompts to how you might move forward, but I want to open the conversation up to have a broader discussion about this. So let's use the chat box. I'm going to look at what you've been chatting about in the meantime. Oh, someone wasn't able to answer the last poll. I'm sorry about that. Let's use the chat box, which you can give your how you would approach the poll in the chat box if you would like, about how do team members' confidentiality requirements come up with your team's work? How does this express itself in real life, in your real life with a SART? What are the issues that appear? I know some of this from those of you who answered the pre-webinar survey, but let's all have a conversation about that. And while people are answering, Miranda, if you have any thoughts you want to share with everyone that you've seen come up with your work with SARTs, this would be a great time to share those.
Yeah, I know that a couple of teams that I've talked to or worked with in the past have talked about, especially kind of that pressure of like upholding confidentiality standards during various conversations. And kind of knowing like when to make sure to not use like very specific examples when doing especially system change work, to make sure that confidentiality is upheld.
Mhm. Yeah, I hear about that too. And that's why I think that idea of revisiting, establishing those expectations and then revisiting them, making it a space where everyone knows everyone's confidentiality expectations so that everyone is on the same page with them is so important. And another thing with that too is I'm reminded of your Justice League analogy, which I appreciate. And given that everyone does have a role and they're all important and necessary to give survivors and communities ways forward to have a better response to sexual assault, for example, it's important that everyone feels empowered with that and understands everyone's role with that. So this is a really interesting point that's in the chat box situation. I have been a community member on a SART or SMART, as well as a coordinator. Within a meeting, a member not necessarily bound by confidentiality laws, an ancillary member almost blew someone's confidentiality. It freaked out the other members for sure. Yeah. So this brings together a lot of the different points we've been talking about, because some people can share that information without there being any legal reason not to. That doesn't mean it's the best thing for a survivor or the community to have that information shared. So I think in addition to the sorts of conversations that we're talking about, it's really important that an agreement, that a SART have a confidentiality agreement or other CCRTs, and that be reviewed before conversations happen so that everyone's on the same page and understands that. But because that's the thing that will hold some people who don't have these legal confidentiality expectations, including privilege and confidentiality that doctors and lawyers and victim advocates have, that nurses may or may not have, depending on the context of the forensic work they're doing. But that to just make sure that everyone is on the same page about how you approach this stuff, this confidentiality. What are the agreements with the team and how you work together, and what are the consequences when that confidentiality, if it's an expectation for the conversation you're having, what are the consequences for when that information is shared? By which I mean, how are you going to protect the person whose information was shared if you're putting them at risk by sharing that information and it being intentionally or unintentionally shared? A lot of great issues brought up by that question. Thank you for sharing it. So I'm now reading the sectional meetings comment. Oh yeah, I like that idea too. So the idea that dividing up SART meetings into different conversations so that less specific information is shared in some venues and having law enforcement officer and legal specific meetings where these individuals' confidentiality lines up more. I think that opens up some great opportunities for how you can think about, not necessarily in that specific way, though certainly consider that, but other ways in which dividing up conversations might, among other things, help protect the privacy of survivors.
Carol, we also had someone share in the Q&A that they've experienced some challenges navigating appropriate services when advocacy and mental health are both involved. To paraphrase, advocates say, send survivor to us because we're the most confidential under state law. And then mental health says that they are the most confidential. They often say it more nicely.
Yeah. I think when the system is working at its best, we have a menu of options for survivors and their support people about how they can, about what their options are and what are the implications of choosing those options so that they can make informed decisions about those. We have this one pager, it's called a ripple effect, in our campus workbook. So if you'd be interested in seeing it, that would be the resource to request. We have this ripple effect available in many languages. I think close to around a dozen languages. So if you're working with particular populations and think this tool might be useful for you to work with survivors who speak different languages, know that that's the case. But what's really important for survivors to know is that if they talk with this person, this could be the implication, either that this person will protect this information or they will have to share this information, so that survivors are the ones making the choice about who to come to, and that we're generous with each other about what we all have to offer and the risks that may be inherent with sharing information or working with different people in our program, and be specific about that confidentiality and privilege. And a way in which I can be a resource for that is I love to go deep on what are the laws in your jurisdiction, so that in this scenario, to understand what are the mental health, what are the protections for mental health providers, and what are the situations in which they might have to share information. And similarly, what are the protections that victim advocates have in that jurisdiction, and what requirements may they have to share. And then I think what can be useful is to make sure survivors understand both of those things. Sometimes our shorthand gets in the way of giving to allow survivors to make a meaningful choice about what they want to do. On the other hand, I understand most survivors are not looking for an extensive discussion of different people's confidentiality and privilege obligations. So there's some balance there. I feel like I may not be giving a helpful response to this, and I would love the opportunity to talk more deeply about it if that would help, and then we can look at the specifics with that. Now, backing up a bit in the chat box. Yeah, the idea that there is an impression that different confidentiality requirements between government actors and community actors. For example, law enforcement are willing to share information with other law enforcement. Sexual assault, I don't know what an SAO is in your jurisdiction, but not with the people outside the criminal justice system. So yeah, so we're talking about what are the legal requirements for protecting or sharing information. If there's a situation where someone could share the information, where they're allowed to share the information, but they are making a choice not to share the information, then I think that would require a conversation about what's going on here. Is there something that can be done so that there would be a space where we could share more information? But I think the starting point is, what are the legal expectations? Because when I've worked with groups like this, you're typically working with people that if they know what the law is, they're not inclined to violate it or go against it. And it can give authority to an approach. So I find it as a useful starting point. Yeah, that one approach is that being intentional about asking a team for general trends or common barriers they've encountered so that we can avoid getting deep into an information about any one case. That is certainly, when you're talking about social change within a community, an approach that you can take. As I was mentioning earlier, just, like you can say things like, in the past 6 months, we've seen a significant increase in X, or we're hearing more than one time in the past 2 months that a survivor experienced Y. Definitely. Oh, and thank you, State Attorney Office. That helps. Yeah. Any other questions, thoughts, how you've confronted the issues that are raised by other people's questions? Those of you who have been doing this for a while, anything to add or ask that goes beyond that? We will have time to come back if anything else comes up for you. So I want to sum up. Oh, how can we access the ripple effect tool you mentioned? Request our campus workbook on that CCR, on that resource request form that Heather shared at the beginning. If for some reason it's not on the resource request form, I expect that it is, but I don't have the form in front of me. Just type in or write, depending on how you're getting the form back to me, probably type in that you're looking for that, and I can sort it out. Even if you don't find the campus workbook, just make a note and I'll get it to you. Thank you. So let's look at some common themes and ideas for how to move forward with all this, trying to bring it together into some helpful tips for protecting confidentiality as you're working on a SART team. First thing, and we've talked about this several times, identify the confidentiality requirements for each member of your team. I would add to that privilege and think about the broader frame of information sharing. Who can share information, who can't, when, what sort of information, because everyone can share information. It's just some people cannot share personally identifying information or confidential information, for example. So once you've done that, which you may think this is reversed, but I'll explain why I put them in this order. Clearly establish the purpose and expectations for your team. I know many of you already have clearly established the purpose and expectations for your team, but if you haven't yet, or you're revisiting this, the reason I wanted to identify that, to encourage you to identify the confidentiality requirements for team members first, is because you don't want to establish a purpose and expectations for your team that are contrary to what your team is legally allowed to provide with confidentiality, among other things. Develop protocols that respect team members' confidentiality requirements, things that will help people not to understand when people are sharing or not, and how you encourage with each other with that, and see it as a norm that you wouldn't ask people on your team to share information that they're not allowed to share, as part of your encouragement for each other. Revisit the confidentiality protocols regularly, the information sharing protocols regularly. And then lastly, develop a protocol for accidental sharing of confidential information. Some people may need to report a data breach if they're receiving any kind of federal funding, not just VAWA, VOCA, or FIFSA. So it's good from that data breach perspective, along with any laws that are in your jurisdiction. They might be consumer protection laws that have to do with when information is inadvertently shared. We have a model data breach policy. It's geared toward organizations, but it might be useful. We'd be glad to share it with you if that would help. But then, as important, if not more important, excuse me one moment, is having a protocol in place about how you'll stop what you're doing and you'll do an immediate safety assessment about how that sharing of information could be dangerous for the survivor, something that doesn't respect what you know was their wish for the information sharing, how you're going to remedy this from a survivor perspective. And then know that for the members of the team who receive VAWA, VOCA, and FIPSA funding, there's a requirement if they are the ones who share this information inadvertently, because accidents can happen. It's just important that you be prepared for when they do. Those VAWA, VOCA, FIPSA funding recipients have a statutory responsibility to not only inform the person whose information was released that the information was released, but take steps necessary to protect the safety of everyone impacted by the sharing of that information. So it may go beyond that individual. So for example, how this could come up is if you were discussing an incident that happened at a juvenile detention facility and no one knows who made a report that led to the sexual assault coming to light. It could be everyone at that facility could be put at risk by the disclosure because the perpetrator may not know who made the report. And if you're, admittedly, there's one person that you've identified as making the report, but there could be implications for everyone in that facility that this person knows that that person made the report. I'm sure there are better examples, but it's just know that the VAWA, VOCA, FIPSA funding recipients who are providing victim services will have their own responsibilities in response to that accidental sharing. What are your questions about any of this? Or what are ways in which you've managed any of this that you can share with your colleagues who are attending today? And Miranda, I'm glad for you to raise issues or questions that have occurred to you as well. We, as usual, can come back to questions that you may have as we share some additional information with you. I wanted to let you know about some of the resources that the Victim Rights Law Center has to support your work. We have a lot of tip sheets. This is an example of one. It has to do with protecting confidentiality when working with interpreters, but we have other tip sheets that are on that resource request form. We have guides like this one for when you're working from home, which when we first drafted it, we thought might be a short-term thing, but clearly is a longer-term situation for many of us. This is an example of one of those releases of information. We have some videos, including this video that focuses on knowing your rights for homeless women. I would think it would have broader applicability as well. As I mentioned earlier, we have a lot of translations. So this is our mandatory reporting of child abuse flow chart, which talks through the steps, the analysis that VAWA, VOCA, and FIPSA funded victim service providers need to take when they are considering whether or not there's a statutory mandate to report. I wouldn't expect most of you to be able to know that from this example, but just know we have a lot of resources, and well, we have some resources in a lot of languages, and we expect to have more by the end of September or early October. We have sample motions for those of you who are attorneys or working with attorneys. We have these jurisdiction-specific FAQs. I mentioned them earlier. They cover general privacy law. We have one that focuses just on minors and the age of consent and emancipation and things that we thought people need to know if they're working with minors, so that you're not having these questions about can we serve this person or not, because we know that 12 to 22-year-olds are assaulted more than others. in an SA context. So it's very important that you're solid about serving minors. And then we have that clergy FAQ I mentioned, and then know that we have the research available for elders and adults with disabilities as well. So we can answer your jurisdiction specific questions about those. Miranda, would you please share with us information about SVJI's tools and resources?
Of course. Thank you so much, Carol, for sharing all that information with us today. Some of SVJI resources do include some toolkits. So, for example, on the screen, you can see we have our sexual assault response team starter kit, which is a guide for coordinators and folks that are looking to start a SART. We also have various templates as resources, including a template for protocol development and also templates as far as how to facilitate meetings and develop a mission and vision statement for your SART. We have various videos such as webinars like this one today, as well as we have a couple of shorter videos discussing what a SART is and kind of going through what we talked about at the very beginning of this presentation. We also have various guides. For example, our Are We Making a Difference guide, which is our evaluation guidebook that we used to discuss various forms of evaluation SARTs may choose to do. And another is our case file review guidebook for those that are interested in case file review. Lastly, we do have our Rural Realities blog where we discuss various topics related to SART work. I think some of our most recent topics were related to virtual engagement, and it is focused on rural audiences and rural SARTs. However, some information may be helpful for more urban or suburban SARTs as well. So those are just a few of our resources at the Sexual Violence Justice Institute. I also wanted to just take a moment to ask everyone to fill out our survey in regards to this webinar today. So Heather, if you could pop that into the chat when you are able to, thank you. We do have a feedback survey for you all to fill out in regards to this webinar today.
Oh, were you done?
I'm done. Go ahead.
Okay, thank you. So here is the contact information from Miranda and from me. So much of the analysis and thinking about information sharing in the context of SARTs is specific to your jurisdiction, and you may have specific questions about that. And we welcome and invite those questions. So please feel free to reach out to us if we can support you in any way with that work, or if there's something that we discussed today that on further reflection you forget or it doesn't make sense, any sort of feedback or any way we can support you with the incredibly important, valuable, and sometimes tricky work of SARTs and other CCRTs. Something I want to flag about Miranda is that she co-facilitated this webinar today with 2 hours notice, and I just want to flag what a fabulous job she did. Thank you, Miranda. And also want to share my appreciation for all the tech work that Heather did today on what I think was her first webinar. So go team.
And we want to thank you, Carol, for sharing so much information and being an amazing resource for all of our folks. And I always learn so much whenever I get to speak to you, and I always appreciate being in space with you and in space with everyone else and getting to see and hear folks from across the country discuss issues related to confidentiality and teaming. Does anyone have any questions that they've now thought of before we close out this webinar?
With a reminder that you can reach out to us individually too if this isn't the place or time for them. In that case, thank you so much for being here with us today. You do such important work, and the extent to which we can help it be easier in any way, that's what we want to do.
Thank you all so much. All right.